Good morning. Welcome to this meeting of this hearing being held by the Bucks County Board of Elections. I'm going to call the meeting to order. Is there any generic public comment before we start? I see no hands. Okay. I'm going to entertain a motion to open the hearing. Is that the first thing to do, correct?
Yes, that would be correct.
All right. So is there a motion to open the hearing?
So moved.
Okay, motion made and seconded. Hearing, all in favor?
Aye.
All right.
Mr. Chair, thank you. We're here today to have a hearing to determine the challenges that have been made. There have been 17 challenges made to provisional ballots. Just as an introductory matter, we'll start with Mr. Freitag providing testimony on each of the exhibits. The board has been provided, for the public's knowledge, a spreadsheet here listing the 17 provisional ballots that have been challenged, and also copies of the provisional ballot envelope for their reference. So to start, we'll go over the first provisional ballot. It pertains to a voter named Chino Duru, and we would ask Mr. Freitag to be sworn in.
I do.
Mr. Freitag, can you, what's your position here at the county?
I'm the director of the Bucks County Board of Elections.
And how long have you been with the Board of Elections?
Since 2014.
And how long have you been the director of the Board of Elections?
Since 2019.
All right, can you explain or just describe the ballot at issue here, Mr. Duru's ballot?
Mr. Duru applied for an absentee ballot, and it was not returned to the county. When he went to the polls, he did not have it with him to remit, so he was required to do a provisional ballot.
And did he file a provisional ballot?
Yes.
When he filed this provisional ballot, were there anything unusual about the outer envelope?
The voter signed the affidavit, however, he did not sign the declaration.
So when you say affidavit, that's block 2 on the voter, on the outer envelope, is that right?
That's correct.
But block 4, where it says voter signature, there is no signature there.
That's correct.
What has been the Board of Elections' past practices regarding provisional ballots with just one signature like this absentee ballot has?
Past practice has been, so long as one or the other is signed, we would recommend it to be count.
And was that the recommendation made at the earlier Board of Elections meeting on this ballot?
Yes, it was.
All right, thank you, Mr. Freitag. Now we'll ask if the party that challenged this provisional ballot come forward and raise your challenge.
Yes, Shoheen Vance, V-A-N-C-E. First name is S-H-O-H-I-N. I think the facts are largely undisputed here, and my argument, frankly, will apply to the first 15 of the challenges. First 16, first 14, of the challenges. And it's a straightforward matter of statute and statutory construction and interpretation. As some of you may recall, I was here last week, and I believe Commissioner DiGirolamo, you raised the point, and others may have as well, that it would be nice if the legislature gave us some clearer statutes, if you had some clearer guidance on what to do in certain situations. And this actually is one such example. The Section 1210 of the Election Code, 25 PS 3050, spells out precisely not only what a voter must do when submitting a provisional ballot, but also spells out the consequences for failing to put a signature both in the affidavit box and the declaration box. And it's abundantly clear. The provision says the ballot shall not be counted if either of those signatures are missing. This is not a situation where the mandatory versus directory language and interpretation needs to be delved into, because the legislature has made clear what happens if the voter fails to adhere to one of these requirements. It's a little bit different than in the mail-in situation, where it just says the voter shall affix the date and signature, because again, the statute says exactly what happens if the voter doesn't do so. And to the extent the statute isn't abundantly clear on this, this was confirmed in 2020 in a decision by the Commonwealth Court in Allegheny County Provisional Ballots in the 2020 general election. And that's docket number 1161 CD 2020, where Allegheny County, their practice was precisely what apparently the practice here has been for in the past, where if one of the signatures is there, Allegheny County would proceed to canvass those votes. The Commonwealth Court, in an opinion written by Judge McCullough and joined by now Justice Robson, reversed that decision and mandated and directed the Allegheny County Board of Allegheny County Board of Elections to set those ballots aside. It said those ballots cannot be counted because the legislature has made it clear what the consequences of failing to adhere to the statutory prescriptions are. There's now, as far as what the prior practice may have been here, I understand that in the past, perhaps these ballots were counted, but the fact is that that cannot trump the statutory language, nor can it trump the Commonwealth Court's decision in a case that's essentially identical to this one. Beyond that, I really don't think there's much else to be said here, because again, the statute is abundantly clear. It's not one of those situations where that board is required to decipher an ambiguity about, what does it mean to fill out. It's not, there's no lack of clarity here. I'm happy to answer any questions, either from council or from the board, but in my view, and as confirmed by the Commonwealth Court, this is a clear-cut issue.
Okay, are there any questions for Mr. Vance?
I've got some questions. Can I don't know who to direct them to. Maybe, can I start with my questions for Tom Freitag? This voter initially wanted to vote absentee.
Correct.
Do we know the reason, or do you know the reason why he needed to vote absentee, or thought he wanted to vote absentee?
He applied for an absentee ballot. I do not have the application with me to see what the reason supplied was.
So he received in the mail an absentee ballot and did not send it back in,
Correct.
and showed up at this polling place and wanted to vote.
Correct.
So when they looked in the poll book, there was information in there that he applied for an absentee and received it, right?
Correct.
And he did not have his ballot with him.
Correct.
Okay, so they said he could vote provisionally, and that's what he did, right? So I have this in front of me, right? And it's saying it is missing signature and date in block 4, which I'm looking at, and there is no signature or date in block 4. This is actually a copy of what he signed at the polling place, correct?
That's correct.
Okay. You're saying traditionally or historically, since absentee votes were not part of Act 77 in the mail-in, that before this Board of Commissioners, the previous board and boards had voted on including a situation like this as a valid vote. Is that correct?
That's correct.
So this has been, we've said that this is a valid vote going back before Act 77, before 2020, that the previous board and boards of commissioners would have accepted this.
Yes, so if the signature and date were missing in one section or the other, but not both, for any reason.
And I'm maybe going out a little bit of a turn here, but as I'm looking down, the next group of people, this is only one vote, but the next group of people is a 1, 2, 3, 4, 5, 6, which are in a similar, in the same type of similar category. And it looks, I mean, this gentleman voted in Langhorne, and in the next group of people, there's 1, 2, 3 other people that voted in Langhorne. Is there a link here if somebody did something wrong, possibly at the polling place and not giving out good information? I mean, when in the whole county of Bucks County, you know, most of them seem to be down 1, 2, 3. There's 4 out of 7 of them are in from Langhorne. I mean, is there a common thread or a correlation here why this happened? The 4 out of 7, it was in Langhorne, and
They're in some different precincts. It looks like Northampton 14 is in the second mail-in section, is the first and last 2. The other 32,000 one would be Pendle Borough. 22400, I believe that's Middletown, Upper 4. Do you know? One of the Middletown, I'm not sure, can't remember off the top of my head. But at our election training for poll workers, we do remind them that they should sign both sections.
okay. And Mr. Vance, in your presentation, you, on this one vote, you said this is in statute that it must be signed and dated in both places?
Correct. And so it's section 1210, 8.4, 5, Roman numeral, small Roman numeral 2. And here's what it says. A provisional ballot shall not be counted if A, either the provisional ballot envelope under clause 3 or the affidavit under clause 2 is not signed by the individual.
What year was that?
Either or.
What year?
Oh, this was enacted, I believe, in 2002 or 2004, but then it was amended to include the mail-in to make some minor changes with Act 77. So the General Assembly clearly revisited this provision and left it exactly as is with regard to the requirement of the signature. And I do want to address your point about potentially, you know, there being an issue with receiving bad instructions. It's interesting because in the case I referenced in Ray-Allegheny County, the Board of Elections there also thought that that could be the issue, that some judges of elections were giving bad instructions. And what the court held, the Commonwealth Court, is that that's irrelevant. It's in the statute. And also, just as in that case, what we don't have here is any actual real-life testimony or evidence showing that there was bad instruction. It could be, but I think absent a clear showing that this was an error on the part of the election officials, the statute has to be followed.
Not being familiar, so the person was handed this to fill out, right, at the polls?
That's correct.
Fills it out, and he turns it back into one of the poll workers?
So he would fill out the envelope, then be given his ballot and secrecy envelope where he would vote his ballot, put it in the secrecy envelope, and then return it to the judge of elections to be signed.
Okay. Would the judge of elections review what he had done at all, as far as the signature and the date?
They should.
So the judge of elections could have or should have noticed that this wasn't signed and dated correctly.
They could have, yes.
Mr. Freitag, what's your training? I know that you train the judge of elections. Do you train them to review these envelopes after the voters fill them out? What's the training that the Board of Election does on this?
We have actually a PowerPoint presentation as well as the election manual where it shows what sections need to be completed by the voters, what sections need to be completed by the election officials to ensure that the ballot is properly filled out, which does have both sections saying that they need to be signed.
And their signature that they indicate on the bottom, you'll see in the bottom, you see the judge of elections signs it, and the minority inspector, I think it's cut off on some of the copies, they sign as well. When they sign that, that's after the voter has filled out the top information, is that right?
That's correct.
Could you, just to refresh my memory, could you just let us know what are the reasons that somebody might want to vote absentee?
If they are going to be out of their municipality on election day, or if they have a illness or disability that would prevent them from making it to the polling place.
Okay. So a disability, they thought they were going to be out of the county on election day.
Yes. Prior to Act 77, if somebody applied for an absentee or a mail-in, they were actually required, or sorry, mail-ins didn't exist prior to. If they applied for an absentee, they were actually required to go to their polling place because absentees were previously sent there, where they would then void the absentee and vote conventionally.
Okay. I'm done asking questions, I think.
Just first of all, on this particular one, this is the majority inspector or the judge of elections who did not pick a reason for the ballot not to be necessary, correct?
I believe they are challenging on the lack of a signature.
I know, but they didn't. Somebody for this.
They did not, but looking, when we received the provisional ballot and looked up the voter, we saw that a absentee ballot was issued but not returned.
So I guess I just wanted to make a point that this judge of elections missed this too, or forgot, or was confused. So there was some, is that correct?
That's correct.
So, you know, I know when I dropped off my mail-in ballot, and I ought to know how to figure this out, right? But you guys look at it before you took it from me and made sure that it was okay before you said go.
Correct.
So even here, you check on people, even if it's a commissioner, somebody who should know what they're doing. So I would expect that the judge of elections should have been checking this and making sure it was okay. People who come in and are asking to vote provisionally are usually extremely anxious, don't always know what they're doing, and they're often on guard that someone's going to challenge them. So this, you tend to rely on what this person's telling you to do. So that's one of the reasons that we have historically always counted these votes.
Okay. Something, just going back to Commissioner DiGirolamo's question about why somebody would, potentially, why they would apply for an absentee ballot. I know in speaking with you, Mr. Freitag, you mentioned that if someone applied online for an absentee or mail-in, that there is an early question somewhere in the process of applying online that depending on if you answer that question a certain way, it automatically kicks you to the absentee ballot form, even if you really didn't want to vote absentee because you're not going to be out of town, you're not ill, you don't have a disability, you just were looking to apply for mail-in. But there is sometimes people get tripped up and sent to the absentee and they just filled out because they don't really know the difference. That's
correct. If you apply online on the Pennsylvania Department of State's website, it asks you 3 questions. It asks if you're military or civilian overseas voter, if you will be out of your municipality, or if you are applying for a reason of a illness or disability. If you answer yes to if you answer yes to the first question, it will direct you to the FVAP, Federal Voter Assistance Program website. If you answer yes to the other two, it will direct you to an absentee application. If you answer no to all three, it will direct you to a mail-in application because a mail-in ballot does not require a reason.
Right. I mean, technically speaking, because I'm usually here pretty much all day on election day, I'm not in my municipality on election day during times when polls are open. So theoretically, I could apply for an absentee ballot, can still qualify because I'm not in my municipality on election day. But that's different than being sort of in California.
Yes, and Act 12 of 2020 actually eliminated a challenge for if you should have applied for a mail-in but applied for an absentee or vice versa.
Okay. Okay. All right. And I did note one thing that was pointed out already by Ms. Greaser, which is that this was signed, as I believe all of them were signed by the judges of election after the voter would have turned this back in, and by the minority inspector, and dated, it looks like, yeah. So, okay. Any other questions for Mr. Vance?
I would like to make one additional point, by the way, about the dual signatures. While it may seem redundant that the statute requires 2 signatures, there's actually a very good reason, by the way. Regardless of how judges of elections maybe mishandle or handle it on election day, Box 2 is supposed to be signed before you receive your ballot. Box 2 is an attestation of your qualification to vote, which you're making a representation to the judge of elections. Then you receive your ballot, you mark it in secret, put it inside the secrecy envelope, put it back inside the provisional ballot envelope, and then you sign Box 4. So these signatures are not supposed to be, as a matter of law, are not supposed to be rendered simultaneously. They're actually supposed to be rendered, Box 2 first, signed or voted, and then Box 4. So there is a good reason for that. And just, again, in closing, we may think this law is stupid. Perhaps everyone in this room does, but that's not, our job. It is not either certainly not my job, nor yours, respectfully, nor anybody else in this room to change the law on this. The legislature is tasked with changing the law on something this clear, and that's what the court's response has been. And one last note on the decision from the Commonwealth Court that was appealed or attempted to be appealed to the state Supreme Court, and the state Supreme Court denied review. So I think that further speaks to the clarity of the statute and the requirement that these provisional ballots cannot be counted. Thank you.
Mr. Vance, just for clarification, you had mentioned that argument, that statement you made applied to the first 14. That would be Duru, Cataldo, Fazano, Murad, Rao, Sekleman, Forlenza, Gaydon, Bush, Ward, Stewart, Forth, Westhoff, and Radcliffe. Is that right?
Let me just make sure.
Should also be Merchiori, right? Looks like the same issue with Merchiori.
That's a slightly different issue, but we'll cover that in
Okay,
just a minute,
okay.
Commissioner. Yeah.
Correct. That's correct.
Okay, and before we move on to the next, we'll continue with these. So I would ask that those be marked, each of those provisional ballots be marked into the record, as indicated, as I just read, 1 through 14. Thank you, Mr. Vance. I would ask if any of those voters are present that we just named off, please come forward at this time. If you had any statement you'd like to make. Apparently there are no voters present that were just named. Would the other party or candidate involved in this case like to make any response to this statement? Apparently so. Yes, sir. Come forward and identify yourself, please.
Matthew Hoover here on behalf of the Bucks County Democratic Committee. And I'll be brief, and I think everything I'm going to say here can be copy and pasted for all the ballots that are involved. And that's what we're here about today is all or almost all questions of law as opposed to questions of fact. And when I say that, and I understand that the hearing we have to have today is a creature of statute, it has to happen. But nothing's changed for this board for your decision that you made last week, as opposed that you make the decision today. The law is the same, the advice you got from your solicitor is the same, and nothing's changed as to why these votes should be counted. To address Mr. Vance's argument briefly, first, the Commonwealth Court case that he discussed is non-precedential. The Commonwealth Court made the decision as far as how they wanted to handle the case. Do we want this to be precedential law or not? And they chose not. And therefore, it's nothing that binds the Commonwealth, any of the boards of elections within the Commonwealth or the courts within the Commonwealth to follow. And if it was precedential, our state Supreme Court probably would have had something to say about it, but because it wasn't, I would suggest that's the reason why it ended well it did. Specific to the issues with the signatures and all the technical reasons why we're here about today, I agree with the points brought up by the board. Mr. Freitag, these are easily things that could have happened because of judge of elections errors or poll worker errors who review these ballots after they are returned to them and executed. Each of these ballots was made by a registered voter. That's not in dispute. Each of these people had a right to vote. That's not in dispute. It's a matter of, because of a technical error, are we going to make this vote not count? And the reason specific to the statute, I believe you can look at the intent of the statute as far as to the purpose of it and find that it's not meant to throw out this vote, these specific votes. There's no specific law to the contrary. Back to what was raised last week with regards to the materiality of it, you can also look as to say, is this material to a voter's qualifications? In each of these cases, like I said, these are voters that are registered voters, non-dispute. These are people who have the right to vote and went through all the paperwork in order to be able to have the right to vote. That's not in dispute. We know there's a qualified voters. The question is, because of a technical reason, are we going to throw out the right to vote? Or throw out this specific vote, excuse me. And again, specific to the signatures and any other technical reasons, I would urge the board to stay consistent with your decision last week that each of these votes should count, and there isn't a reason why that each of these qualified voters should not be given a right for their vote to count. That's all I've got, unless there's questions.
Any questions, Mr. Hoover?
No.
All right, thank you.
Thank you.
Okay, board, we'll move on to the next challenge, and that is, we'll mark as number 15, exhibit number 15, Sydney Merchishore. Mr. Vance, if you'll come forward, this is a challenge that they made, but it's my understanding that they are withdrawing their challenge after further review of this envelope.
Correct, we're withdrawing that one.
Which ones are down? Is that the second group?
Second page.
Second page, third from the bottom,
Mercury.
Mercury, thank you, Commissioner.
Okay.
Yeah, we're withdrawing that one, and I think our withdrawal of that, by the way, speaks to what we're asking for here, which is that the only thing we're asking for is for the statute to be scrupulously followed. Minor irregularities, we did not challenge. Minor omissions, we did not challenge. But when something is omitted that is expressly required to be, by statute to be there, I think it's this board's duty to follow the law.
So I have a question. So looking at Ms. Mercuri's envelope, it is signed in box 2, it is signed in box 4. But box 4 also requires a printed name and the date, but neither of those are present.
Correct.
So you consider those minor? You consider not having a date minor?
Well, no, I wouldn't say that. What I would say is the statute doesn't say the date has to be there, and the statute doesn't expressly say if the date is missing, it shall not be counted.
Okay.
The statute expressly says if the signature is not there, and it also says, unlike the mail-in ballot statute, for example, where it says the voter shall date and sign, the provisional ballot statute doesn't say the voter shall date and sign. It says the voter shall sign. I'm just following the statutory language.
Okay. All right, thank you. All right, Mr. Greaser.
Yes, the next, number 16, this is Dean, Elliott, and Johnson, right? This is one where Mr. Freitag can explain our recommendation, I believe our recommendation, the staff's recommendation is going to change to the board. This is one that we recommended to be counted before, but our recommendation is going to change to be uncounted based on a registration error. But go ahead, Mr. Freitag.
Yes, we had initially suggested for this to be counted. However, under further review, the application came over from the Department of State with valid applications that were received timely by the 24th of October. However, this one mixed in was actually received October 26th, and the deadline to register was October 24th. It was mistakenly processed because it came in with multiple timely applications. So we would recommend this not be counted as it wasn't received prior to the registration deadline.
Mr. Freitag, if you had other ballots that you had received with a registration date of 10/26, were those counted or not counted?
They would have been not counted if we knew they were registered after the deadline.
Okay, thank you.
Any questions for Mr. Freitag? No? Okay, assuming no comments from representatives from the party, okay.
Thank you, Commissioner. The last one we have is number 17. If I didn't indicate, Johnson was Exhibit 16. Number 17 is Deborah Masters. Again, I'll turn to Mr. Freitag to explain kind of the procedural history of this one, how this voter attempted to vote and then cure that vote.
So Ms. Masters applied for a mail-in ballot and returned it. However, it was not put within its secrecy envelope. So we have the ballot here. It has not been counted because that it was not in the required secrecy envelope. The voter then went to their polling place to vote provisionally. Because they were marked as having their ballot returned, their only option was to vote provisionally at the polls. Because the mail-in ballot was not counted, our recommendation would be that the provisional be counted.
Mr. Ford, did you have any comments? Or Vance, I'm sorry, not Mr. Ford.
I do, right. This situation is exactly like the first 14 that we discussed. It is in statute. Again, the statute says if the provisional ballot shall not be counted if the voter's mail-in or absentee ballot is received in a timely manner. It was received. The fact that it was defective doesn't matter. And again, this was addressed by the Commonwealth Court in the decision I referenced earlier, which my colleague correctly points out, was unpublished, which means that it is not, strictly speaking, binding, but it is nevertheless highly persuasive, being issued by an appellate court with statewide jurisdiction. And as far as the Supreme Court's decision not to take up further review, having clerked for the state Supreme Court, I can tell you they often take up cases that are unpublished. So I don't think that that is necessarily the reason why that decision was not considered for further review. This frankly met all of the criteria for review, having been an issue of first impression. But I think the court's perspective, we can surmise, was that this is a pretty clear case of what the statute requires. And again, in Allegheny County, the exact same situation, and the Commonwealth Court directed the board not to count those ballots.
Questions, Mr. Vance? No? Mr.
Is
Hoop?
Ms. Masters present? Apparently not. Mr. Hoover, did you want to make any comment on this case?
Nothing other than what I've already said. Thank you.
Mr. Freitag, one follow-up question. You often receive DOS, Department of State guidance regarding elections and changing recommendations, that sort of thing. Is that accurate?
That's correct.
Did you receive any specific Department of State guidance on this issue that was just presented with Ms. Masters' type of ballot?
Yes, Department of State guidance says that we should count ballots for voters who went to the polling place after an error on their absentee or mail-in and are able to cure by doing a provisional.
Thank you, nothing further.
Any comments or questions from Mr. Greaser, Mr. Freitag from the board? No? Okay. All right, then, so we have items 1 through 14. Item 15 is being withdrawn. Recommendation to not count number 16. Recommendation to count number 17. All right, and I'm sorry, I should have said there is a recommendation is to count 1 through 14 based from our staff. Okay. Is there a motion regarding numbers 1 through 14?
Mr. Chairman, could I just?
Sure.
A moment. I'm just a little torn with somebody. I'm just a little torn from taking these all up in one. So you're recommending that we vote on number 1 through 14?
Mr. Chair, if I may, what I suggest is the challenge made by Mr. Vance was similar on 1 through 14. He indicated himself he has the same challenge, the same basis for that challenge through 1 through 14. So I think you could vote on those 14 separate. We heard no comment from the public, any of these individual voters. So I believe if you feel like it, your wish, you could vote those 1 through 14. The motion would be either to reject or accept the challenge made. I would suggest on those 14 ballots.
Okay, say that again, Dan, I'm sorry.
Yeah, the motion.
What? I'm not the smartest guy in the world, but this is really challenging to try to figure out here what to do. My initial sense tells me that if we've been doing this in previous boards historically, counting these ballots or certain ballots, in my mind, I mean, that's a reason to include them. But I'm really struggling with this. I'm telling you, I really am, trying to understand which ones, the difference between these. And I think Mr. Vance's point about, and I've been saying this pretty all along, to try to clarify what we're doing here. I don't want to take away somebody who might have made a mistake not of their own doing, take away their vote. I don't think that's right either. I don't know. I'm really struggling with this. So we're going to take which are you?
Numbers 1 through 14.
First, they're not numbered. So
Yeah.
what does that mean? 1 through none of these are numbered on the sheet that I have.
Yeah.
So you're
For
taking,
Mr. Chino down through Ms. Radcliffe, all basically have the same
so
issue.
the first 14
First
names.
14.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. To Radcliffe.
To Radcliffe, correct.
Okay.
They all essentially have the same issue, same problem, and Mr. Vance has said he has the same challenge
Okay.
for all 14.
Now, the Board of Election is recommending that we count all of these.
That's correct.
Yeah, you made the decision to count these already in a previous meeting.
Okay.
And they've challenged that decision. That's where we're at right now procedurally. So you need to decide whether you're going to accept that challenge that they've made or deny their challenge and count the
Okay, so the
ballots.
3 of us voted, it was 3-0 vote to count these first 14? in the previous Board of Election?
I believe it was, yes.
We're just voting to affirm what we already decided,
Basically, yes, if that's your wish.
or deny. So could I make a motion to affirm all decisions previously made, or?
To reject the challenge, basically, to these 14.
Yeah, I would cover these 14 as a starting point, and then do the remaining ballots. But yes, if I may suggest the motion, it would be to reject the challenges to the following ballots: Duru, Cataldo, Thomas Fizano, Valerie Fizano, Murard, Rao, Seckelman, Forlenza, Gadenbush, Ward, Stewart, Forth, Westhoff, and Radcliffe.
So I would make a motion to reject the challenges for the aforementioned names.
I'll second.
Okay, motion made and seconded. All in favor?
Aye.
All right, so the next name, Ms. Mercury, that's been withdrawn, that challenge is withdrawn, so we don't have to take any action on that, correct?
That's correct.
Okay. Next would be Dean Elliott Johnson, and this is a recommendation from our Board of Elections to not count that one because that application came in after the deadline.
That's correct.
And so we would accept the challenge, essentially.
That's right, and not count that ballot.
Okay. Is there a motion to accept the challenge to the ballot of Dean Elliott
moved.
Johnson?
Second.
All in favor?
Aye.
Okay. 17, that challenge is because Ms. Masters submitted a mail-in ballot. It came here. Our staff recognized the fact that it was naked, but without opening it, they could tell by looking at it, like the envelope. Ms. Masters was informed of this, decided to vote provisionally so that she could vote. And so this would be counting we voted to count the provisional, and because we were going to be denying the mail-in ballot we'd received, the challenge is to not count Ms. Masters because she submitted a mail-in ballot. So is there a recommendation to deny the challenge to Ms. Masters based on the recommendation of our staff?
So moved.
Second.
All in favor?
Aye.
Okay. That's it? Okay. So just as a final comment is there a motion to, we'll suspend the hearing, then we'll adjourn the meeting after that, right? Or stop?
Yes, that's fine.
Is there a motion
Close the hearing.
to close the hearing?
So moved.
Motion to close the hearing.
Oh, second.
All in favor?
Aye.
Aye.
Okay. So before adjourning, there's an old saying, because I respect the argument that's being made by Mr. Vance. There's an old saying that the last perfect law was written on tablets and carried down from Mount Sinai. There have been a lot of imperfect laws. Most laws are imperfect. I think the job of this board, which in on a bipartisan fashion, was to evaluate the impact of that law, imperfect laws as they are, and try to protect the most sacred right we have in this country, which is the right to vote, which is, I think, what we did. It's an awful big step to deny people the right to vote, and I feel that's really kind of the driving force for us. It'd be wonderful if all the laws written were perfect, but we're the ones who carry them out. Noticing that more and more in my role as a commissioner, with no disrespect intended to my colleague, former state representative. The laws sometimes get passed in Harrisburg are often passed by people who don't necessarily put the rubber to the road, and we're the ones who are realizing some of the issues and problems. So I'm hoping they listen to us and other county commissioners and council people about changing these laws. So, okay, sure.
Yeah, and I've told the story before, but in case there's some people here who might not have heard it, it's something that left a big impression on me. And I grew up on my grandfather's farm in Bensalem, and we lived with my grandparents. And my grandparents were both immigrants from Italy, and they became naturalized citizens. And one of the enduring memories I have of Election Day, and everybody worked on the farm. My grandmother worked out in the field, and I worked out in the field as a young boy. On Election Day, I can remember, and it was every Election Day, both of my grandparents in the afternoon, leaving the field, going inside the house, putting their Sunday best clothes on, and both of them driving out to the polls to vote. They were naturalized citizens, but it was so important for them to have their voices heard and their vote counted, that they took that time, and again, they put on their Sunday best clothes and went out to vote. And I remembered that vividly as a young boy. Every Election Day, my grandparents did that. So much that they loved this new country of theirs. And again, so much that they thought that it was important to vote and be heard. And that's why at times I struggle with some of these issues, because I think of my grandparents, and I would not want to take a vote away from everybody because of somebody else making an error or just somebody making a mistake. So that's why I voted like I did today, thinking of my grandparents. Thank you.
Is there a motion to adjourn?
So moved.
Second.
Sorry, motion adjourned, made and seconded. All in favor?
Aye.
Thank you.